appeals. And yeah, both people's things you should take. That is called, that's why we are before you.
Started with the Ram Ram.
Yes. Yes.
And this and that. So it is all in the Indian society. We is also a humble reflection that I am not saying a egoistic word I. So we always say like that in our.
I want to add that, sir, agreed. You are so kind, you are so gentle. I am not saying, sir, but when you say here we means you are representing IBPI, that investigation authority. Therefore, I won't get a judgment proper. That is what my apprehension. Anyway, I'll take your word, sir. Anyway, I'll take your word. I'll take your word. Yes.
And you are a book at mythology. So you should understand the mythology why we say we all the time.
No, sir, I wrote Ramayana book also. It's there in video. Anyway, para 12, sir. I request you. After finishing it, I will come to your question. I will answer. Here, please see what the IBPI is mentioning. You see, it has been alleged that by sharing the valuation report with the prospective scheme proponents, he has provided undue advantage to an interested party and failed to act objectively and did not take sufficient measure to maximize. So all this went into the discussion. It is not a mere valuation report circulation. Now I will explain you. Now everything is wrong. Please note this point. This is not a case of mine. That means they have decided on the basis of 1. I have circulated with an objective of 1. Provided undue advantage to an interested party. Who is that interested party? 2. Failed to act objectively and did not take sufficient measures. Sufficient measures means that disclosure statement, non-disclosure agreement should be taken, which I have taken. Now, now I will proceed to explain. Your question is this, sir. Why did you decide to circulate the valuation report? I will answer that. Point number 1. When the liquidation order was pronounced, SR number 217 of 20, para 12, mentions about the liquidation value. Therefore, I have not disclosed anything. It is the order of the NCLT. Point number 1. And 2, that valuation was done 2 years ago. And this is a scheme of compromise, which should be completed in 90 days. That is also the court has given me the target. It was a COVID period, serious period of COVID, and I appointed 2 valuers for machinery, 2 valuers for the land and buildings. But one person, by the day he went, it was a lockdown. That you can check up. This is COVID-19 was serious. But I got very good response. Unlike CIRP, where the promoters were offered to give back at 100 crores cash. They turned down that. And in liquidation, they came back offering 700 crores of rupees. That's why I got into problems. And IDBI, like COC, was informed. They have appreciated my work. First SEC, para 8. They have appreciated. Then Joint Lenders Forum themselves have asked me to negotiate. And I called everybody to discuss with the stakeholders, Joint Lender Forum 2. And thereafter only I have proceeded to file this 816. Therefore, why did you do it? This is the reason. After 2 years COVID impact, everybody wanted the revaluation. After informing them, after taking the sufficient non-disclosure agreement, 2 crores of rupees EMDs with me, I will forfeit that. And I got 500 crores. Therefore, it is wrong to say I helped any part. All the people were circulated. It is misleading. The problem is when the matter goes to the court, adjudication is different. When the matter comes to tribunal, technical subject, like you are experts, so you will be able to decide. Now, one point is very clear. Point 1. The actual report referred to was not checked. Please, sir. Yeah, I will show. Yes, Alboma. Yes.
It is
It is a section 230. It is going under section 230. It is not under liquidation.
And I'm saying you have not done the, as a liquidator, you have not done the fresh evaluation of the assets.
I may not be saying like that. That is wrong. I am a liquidator as on that date, but I am going through the scheme of 230. It is already clear. Arun Kumar Jagat Ramka, if you see, the Supreme Court very beautifully said that CIRP is a separate part. There are provisions and regulations. And liquidation 33, 34 to 54, it talks about liquidation and liquidation regulations. You are introduced 230. Therefore, that regulations is not applicable. Then you said 2B will apply and all. So far as this is concerned, this is going under scheme. But be as it may, even assuming I have done it as a liquidator, I will take the...
I'm asking a simple question.
Yes.
That liquidation was ordered during liquidator or no?
Yes, I am the liquidator.
Then you ordered, but the liquidation during the liquidation period was not completed.
No. A CIRP process was completed. And then therefore there was no resolution plans. I was...
CRP, you were...
I am the resolution professional. I am the resolution professional.
So whatever report you were sharing was coming from the CRP period.
Yes. That is the point.
So you have not created any new set of evidence, you just shared the information.
No, it is wrong. I have revalued and that part of the valuation I have shared. Please note that. I am not misleading the court. CIRP valuation is 323 crores and the new valuation is 223 crores.
Price valuation in liquidation was done.
It is not, yes, you can say like that and then we will proceed, but the regulation...
No, I have to see, after hearing you, I am noting down whatever.
Yes.
You can't speak, I mean this, I am repeating.
No, I am clear.
Give me answer. Very simple question, whether you carried out a fresh liquidation or not, valuation during the liquidation, you are saying yes.
This is actual process in 230 is a revised valuation, not fresh valuation. That was our argument even in NCLA.
So revised valuation you did.
Because of that reason. The reason is COVID-19 and the reason is already it is included in the report.
So you did it through valuers or you did yourself?
No, valuers appointed. Through the IBBI registered valuers, 2 valuers for plant and machinery, 2 valuers for land and buildings.
That report you shared.
Yes, with the permission of the stakeholders.